Right on. Anyone who's still out hanging out on the expo floor, come on back for an amazing panel. We're going to resume our sessions. I'm very excited for this legal panel. I've had the pleasure of working with most of these people, and a few of them I just got to know, and wow, are they intelligent, smart, brilliant lawyers that we're about to learn a lot from. I like to say it's a free legal advice panel, but they'll kill me if I say that. So just write down what they say. But Brian Farber, who I've known for a long time now, Counsel at Cahill, is going to be joining us with Froelich, partner at Womble and Dickinson, Daley, Epstein, a senior associate at Skadden, Adrian Alvarez, actually one of my co-founders back in 2013 for InvestReady, a compliance company that we started. And then last but not least, Marc Powers, brilliant individual from Miami, former SEC enforcement chief, now teaches blockchain at FIU Law. I've had the pleasure of speaking at that class. Bunch of smart kids. Even smarter individual who's going to moderate this panel. So come on up, everybody. Let's let you get right into it. Deserve a clap.
All right, nice to see everyone. A bigger crowd than 2 years ago, so that's nice to see. Good to be in New York. I spend most of my time now in Miami. Weather's a little bit nicer than here, sorry. A little hot. Today we have a panel. We're going to talk about the Genius Act. I saw part of the last panel, and I see that the business people, business side, is already talking and implementing aspects of this law. But I thought that it was important, because you have this distinguished panel of lawyers, to kind of level set it, because I don't know to what extent all of you are necessarily as educated on what the Genius Act specifically provides, what are the issues concerning it, and how it is being implemented, specifically with the use of legal counsel. So that's what this panel is going to be all about. So starting over there, we have Brian Farber, as Herwick said, who was from Cahill. We have Froelich from Womble, Dickinson, Adrian Alvarez, and Daley, Epstein from Skadden. You heard that I no longer have to do what they do. I've been retired from the practice of law for the last 5 years. Before that, I was at Baker Hostetler. I ran its national securities SEC practice. I started my career at the SEC. And starting in 2017, I got involved immersively in the ecosystem of crypto and blockchain, both advising clients, representing clients, and then actually investing in it. And I'm still very active in it today. So what I want to do is first have each one of the panelists introduce themselves. Then I'm going to try and level set for all of you here today the aspects of the Genius Act, and then get into the weeds a little bit as to the issues that from a legal perspective we all kind of see, and then even how we use it, and how it intersects with issues such as real-world assets and tokenization of securities and the like. So first, let me start with Brian over there. Why don't you take a minute or two introducing yourself and some of your background, please.
Hi, everybody. I'm Brian Farber at Cahill Gordon. I'm counsel there. Primarily focus on regulatory and capital markets work. Started my career here in New York at a different firm, doing just that. And then in 2018, left large law firms to go into crypto. That was a very early time, as many of you I think were probably involved back then too. So much so that at my going away party from the firm, the senior partner in my group said, don't do anything embarrassing like get arrested and embarrass the firm. And now that firm does a ton of crypto work. So times have certainly changed. I first went into Consensus in Brooklyn as a lawyer, and then I was the first general counsel at Securitize, so I see some familiar faces here as well. And then I left the industry for a few years to do some private equity work, and now I'm back in the industry again, so I don't really know what that says about me, back for more punishment, but here I am.
Great, thank you. Louis?
Hi, everybody. Nice to meet you and glad to be here. My name is Froelich. I'm a partner at Womble Dickinson. I focus on primarily hedge funds and asset managers, and I also do about half my work in that TradFi, digital assets, securities, commodities, et cetera space. I've been in private practice on and off in NYC for about 20 years. At a large, I think all of us lawyers up here had in-house stints. I spent 8 years at Two Sigma Investments, which is a large quant fund in NYC, where I kind of got thrown into the deep end of all things software, data, and trading.
Great. Thank you. Daley?
Hi, everyone. I'm Daley Epstein. I do litigation and regulation at Skadden. My practice is exclusively blockchain and crypto, and it has been for about 5 years now. I originally started practicing as a lawyer back in Texas, and I worked on my first crypto matter about a decade ago and realized this is the space I want to be in. These are the interesting legal questions. And so I've spent most of my time in private practice at a firm, but I also spent some time in-house at Kraken on their legal team. And thank you for having us.
Thank you, Daley. Adrian?
Hey guys, Adrian Alvarez from Miami originally. I'm the CEO and co-founder of InvestReady. Herwig is actually one of my co-founders, and we actually met back in the day at the Launchpad at the University of Miami. Basically, at InvestReady, we focus on accredited investor verifications for Reg D 506C, but we've also expanded into KYC AML through our partnership with Plaid, and we also do qualified purchasers, QIB, and other verifications like bad actor verifications as well. We also have a service called a credit token, which basically puts our verifications on chain using non-transferable NFTs to whitelist specific wallets for certain verifications. And we've been in the intersection of the TradFi and on-chain world now for a few years, and very excited to finally see this growing into one financial system as well.
Right, so our focus is specifically going to be on stablecoins for a moment. And just to give you a sense of why the Genius Act is important, among other things, it's projected by Citi that the global stablecoin issuance could reach anywhere from 1.9 to almost $4 trillion by 2030, which is only 4 years away. So, that's quite a large market, right? And so let me go back and first tell you the Genius Act, right? Let's level set it for everyone here today of what that act says and what it doesn't say and what it means on a going forward basis and the implementation of it. First, you have that act went into law, was signed by President Trump on July 18th of last year, 2025. And the law becomes effective 18 months after that law was signed into law, or 120 days after the last federal agency puts in final rules regarding it. And we're going to have Brian speak a little bit about that a little bit later. So what exactly is a stablecoin? It's a digital asset which is designed to use as a means of payment or settlement. The last panel was all on settlement, right? Redeemable for a fixed amount of monetary value, and it's not classified as either a security or a deposit, to basically obviously separate it from being subject to the jurisdiction of the SEC or just directly solely of that of the banking regulations. So what are some of the key takeaways? There are three kinds of issuers basically under the law. They're called permitted payment stablecoin issuers, PPSIs. One would be subsidiaries of federally chartered banks. A second category would be non-bank supervised by the OCC or the Office of Control of the Currency. The third would be state chartered banks, which are subject to similar kind of rules and regulations as there are under the federal regime. Two, non-financial public companies generally cannot issue stablecoins unless they're approved by what's called the Stablecoin Certification Review Committee. That is chaired by the three members of that are the chairs of the Federal Reserve, Treasury, and the FDIC. Three, the PPSIs, or permitted payment stablecoin issuers, they have to comply with various rules and regulations, in particular the anti-money laundering rules and the CFT rules, which stands for Countering Financing of Terrorism rules under the bank secrecy laws and other banking regulations. There are segregation of asset rules, and there are monthly reporting requirements about the adequacy of the reserves of any stablecoin issuer. Four, a payment stablecoin, as opposed to a non-payment stablecoin, must be backed one-to-one with the US dollar reserves, US treasuries, and other redeemable assets at par. 5, if a stablecoin issuer has a total issuance of under $10 billion, then it can regulate at the state level. 6, as I alluded to before, stablecoins are not subject to the jurisdiction of the SEC. They're not subject to the jurisdiction of the CFTC. And enforcement specifically of any violations of the Genius Act by the Federal Reserve or the OCC. Another important feature of the Genius Act and stablecoins also that for investors to understand is that there's no insurance. There's no guarantee by the federal government. Unlike, for example, deposits in banks, which are subject to FDIC insurance if the bank goes under, or alternatively, if it's a security, SIPC would otherwise cover securities and cash that you might have at a brokerage account. But another feature of it, which is good for consumer protection, is that the issuers of these stablecoins, if they go bankrupt, the stablecoin holders do have priority in bankruptcy over other creditors, and as against any issuer's reserves. And they're basically, the last thing I'll note as an opening on this is that algorithmic stablecoins, many of you are in the industry long enough to know that the Lunatera stablecoin failure, which cost somewhere to the tune of $50 billion in lost assets for various investors back in 2022, that was an algorithmic stablecoin as opposed to a fixed payment stablecoin, which is covered by the Act here. And although it's not specifically banned by the Genius Act, it doesn't grant them the status as a reserved backed token that you receive. So those are called non-payment stablecoins. So let me first now turn to Daley. So this act, which was quite significant, among other executive orders and the like that President Trump put in place once he went into office, he described, you could probably describe this as the first real federal regime that was put in place regarding a crypto asset or digital asset. What do you see as some of the outstanding issues that arise under the Genius Act, and what does it solve?
Marc, I think that's a really great question. I think Genius is important. It's important to understand with Genius that what it did as the first federal piece of legislation in this space is that it solved the legitimacy problem. But it solved the legitimacy problem for payment stablecoins. It didn't address the rest of market structure. It doesn't address DeFi. It doesn't address a lot of the details as well. So it gives credibility to the payment stablecoins, and it gives requirements in terms of reserves. It tells us who regulates them, and these are all incredibly important for users looking to build trust. But it still left lots of gaps in the market, and there's still a lot of areas that aren't established in the law.
So it doesn't address DeFi protocols and the like. Brian, thank you for that. Brian, let me ask you a question. One other thing that the Act does do is it bars PPSIs, or issuers of stablecoins, from paying yield, or paying interest, or some other kind of mechanism on top of the money you get back on a redeemable basis, on a one-to-one basis. But already you're seeing some sort of exchanges and other kinds of affiliated protocols, and DeFi protocols specifically, providing some sort of quote-unquote rewards, end quote, as opposed to yield or interest, which would be prohibited. Where do you see that no yield provision playing out under the law as opposed to what is going on in the marketplace?
Yeah, I mean, it's sort of interesting because Genius bans yield for the issuer, and then the Senate Banking Committee's text for the Clarity Act that came out in May did something similar, and you may recall from earlier in the year, there was a lot of fighting between Coinbase and other market participants and the banks over whether or not you could have interest on stablecoins. So the proposal in the Clarity Act text, which maybe will pass, maybe it won't pass, I guess we'll know in the next few months, that also bans interest on stablecoins, and it says that you can provide rewards so long as they're tangential to the holding of the assets.
I.e. the legacy financial institutions don't want to be disintermediaried.
Exactly. So for DeFi, I think it's sort of interesting that we're regulating stablecoins and entities that issue stablecoins. We're regulating certain market participants, like public companies like Coinbase, and we're driving yield to unregulated market participants now. DeFi protocols, maybe you want to park your stablecoins in a vault or something and get some sort of return. So I think it's a really interesting opportunity for DeFi. We'll see how it plays out. We'll see what happens with the Clarity Act and whether or not that actually makes in the next few months. But yeah, it's sort of interesting that the regulation may just drive stablecoin yield to unregulated market participants.
Thank you. Adrian, you're the CEO at your company and the compliance attorney there, right? So what compliance issues do you see arising under the Genius Act?
Kind of the same boat. The yield is the main process that I think is going to give people headaches about the compliance end. So there's a lot of companies out there that wanted to follow the BlockFi model from back in the day, where you could just put all of your tokens in and be able to get some yield out of it. That obviously got knocked down. We were actually in talks with BlockFi back in the day about converting their entire process to US accredited investors, because if you go through the securities angle, you can actually still provide yield, go through that process. If you do 506C, if you verify that they're accredited. Now within the last few years, they've actually allowed for, if you have like a minimum of 200,000 for a certain investment, you don't actually even have to go through the accredited investor portion of it. So there's, the compliance end is, the yield seems to be the main process that is going to determine whether or not you have Coinbase become a bank basically de facto, or whether or not you have to go through the securities aspect of it. That is going to be the Clarity Act's actual process that's going to tell us exactly how that structure is going to be. So I think compliance, the main portion is going to be whether or not you're providing yield, and then if you're not providing yield, you can kind of just get into the Genius Act portion of it. If you are, then whatever happens with the Clarity Act is really going to determine it.
Right. Now, we're talking about the Clarity Act, but the real question does become, is that going to happen, right? You've had a number, before for the Genius Act, I think you probably had at least a dozen or more Democrats that voted in favor of it, right? Because that was done a year early on in the administration. But now that people are a year and a half into Trump too, there's been more politicization of the process, and there have been some issue, and I think in part because of some of the crypto transactions involving family members and the like, a lot of the Democratic support that was once there has now either been lost or is now putting new amendments in the Clarity Act to tighten up those kind of prohibitions around any government, any officials having any interest in any kind of tokenization projects. So a side question. Yes, real quick answer. What do we see the chances of the Clarity Act passing this year?
I think it's 50-50. I think, again, the yield portion of it is really the big battle between the establishment banks and the up and coming.
Yeah, if the stablecoins offer yield, then there's no reason to keep money with deposits in the bank, correct?
Put your Coinbase account, and then you get your yield, and you get higher yield than you would from a bank.
Right.
Most of the time,
Right.
I'd say slim, but not impossible. I think I've been in this industry a long time, and you have to temper your expectations in some respect in terms of what the government can do. But I think we'll get there. Whether it's this year is uncertain.
Oh, so you even think, even if there's a change in the Congress, that there's still a chance that it might happen? Interesting. Lewis.
I'm a little more bullish, and I think that the crypto lobby is deep pockets. I think it was the largest contributor to the last campaign, and I think that'll come through in this next few months or later. I guess the one point I would make to the audience is, as Daley mentioned earlier about the gaps even in Genius, I wouldn't necessarily, and I've been watching these panels earlier today, view Clarity as this big cavalry coming and it's all going to be clear, right? I mean, Genius gave legitimacy to a very specific product, right? A very defined product. And Clarity is going to give specificity to securities and sort of internet native digital commodities that are tied to a blockchain. I think for this audience, there's still neither of these acts address the vast majority potential of RWA assets, right? I mean, there's still many legal regimes to be dealt with in terms of what you're tokenizing. So if you have a client coming to tokenize a fund, a house, et cetera, real estate, those are not necessarily touched by any of these acts. So just to be clear, if these pass, they may not necessarily bring all the results that people may expect.
Yeah, right. It's basically market structure. And does provide clarity of jurisdictional issues between the CFTC and the SEC, which is actually a very important aspect from my perspective. What do you think it's going to pass this year?
I looked on Polymarket yesterday, and I think the odds were 40%. They didn't pay me to say that, but I think maybe probably around there. I think at this point it maybe is more of a procedural issue, just with Congress over the summer and trying to get something passed with other priorities before the midterms. So we'll see. I think the next few weeks will be very key in telling as to whether or not this gets through.
Okay, well, thank you for that. I mean, I'm a little bit more pessimistic on the whole thing. Louis, let me turn to you. I understand a lot of your clients are involved in tokenizing real-world assets. Can you walk us through one of those projects that you're assisting on?
Yeah, I recently am still working on tokenization of gold. And I think maybe my prior comment, not to be pessimistic about Clarity, but there are many asset classes that fall through the cracks. So one could say that, oh, we have Clarity Act now, or we have the Genius Act, so we can tokenize this. And then you look and you're like, well, no, wait, it's not covered, right? And I think a lot of digital commodities, you would look into the act, on the spot market at least, you would say, oh, wait, that's not covered by the law. So it doesn't mean you can't do it by any means. It actually may make it more attractive to tokenize, because tokenization lends benefits on liquidity and asset velocity, et cetera, but that can work maybe best when you have a lesser regulated market. So with a tokenization of gold project, I think the one comment I wanted to make to this audience is to really just ask yourself or your clients, one question like 15 times, and it's more of a practical question, which is, this is less Genius Act, but it's, what are you tokenizing, right? What does the token represent, right? With the stock, I think we've all discussed that that can actually be the token, right? You can have a company issue stock in a digitally native format, formatted and recorded on a blockchain. It may seem obvious to this group and to my other panelists, but when you digitize or pixelate a commodity or whatever you want to talk about it, you do have like a stablecoin, except it's not regulated under Genius. You have a token that represents a bar of gold. And I just want to impart upon the audience that when you go to market saying you're tokenizing gold, and then someone reads what you're actually selling them, and it's some securitized Cayman SPV, you've gotten pretty far away from what you set out to do. And a lot of these lessons are kind of hard learned by a lot of these entrepreneurs when they go to tokenize something and they realize it's not as regulated as they thought, and it's really hard from a title, UCC, commercial perspective to actually bring it to market.
Interesting issues there. So Adrian, let me ask you, with the Genius Act, what impact has it had, or will you expect it having on foreign stablecoins?
For sure. I think the underlying reason for the legislation was to kind of disempower Tether just in general. I think that the US government was very nervous about having an unregulated company kind of selling treasuries out there, but it's a little bit of a balance, because the government wants to have the treasuries out there and to establish the US dollar dominance outside of the US. So kind of taking the USDC model, basically legislating it and then forcing companies to choose whether they want to go the regulated route with Circle, or whether they want to continue with Tether, that is getting less and less relevant with MiCA out there, with now Genius. The underlying portion of it was to try to bring the stablecoin into more of a regulated space without killing it, but killing Tether.
But isn't okay? So how is that playing out though? Didn't Tether kind of open up an office?
They did.
So that they, and aren't they now putting just U.S. assets in there so that they would qualify otherwise for purpose of the regulatory scheme?
When I say killing Tether, I mean killing Tether prior to Genius, in that they're either going to, basically.
So bond loan didn't work.
in some ways, I think Tether's shifting what they're doing, and the underlying process is that they want the treasuries out there. They want to make sure that they're using treasuries for the stablecoins, and that if Tether ends up complying, then they'll be brought in. But not having the control over their own treasuries was the main impetus behind the act.
Got it. Thank you. Brian, let me turn to you. I started off by saying that the law becomes effective either in a year and a half or 120 days after final regulations by the agencies responsible for implementing the rules around the Genius Act. There was a joint SEC-CFTC interpretive release back in April, which laid out an analysis and a 5-tier classification for digital commodities to tokenized securities. Can you talk about those classifications and the like and what it means? I see that, and I'm curious to know your opinion, your view on it. I definitely want the Clarity Act to happen, but I saw that as a major step forward in providing clarity for the industry. But I'd like to hear your thoughts.
Yeah, so in March of this year, the SEC and the CFTC put out joint guidance, covered a bunch of things. It had a 5-tier token taxonomy, and I think for people who have been in this industry for a while, we've all gotten used to regulation by enforcement. So to have regulatory agencies put out guidance like this is super helpful, basically saying this is a security, this isn't a security, this might be a security. If you do this, it's not a securities transaction. So to lay it out very simply, 5 categories of tokens. Tokenized securities, let's start there. You're tokenizing equity, you're tokenizing debt. Those are securities, full stop. I think we all understand that. The other 4 categories are not securities. Digital tools, so for example, if you've got a digital ID, that's not a security. Digital collectibles, NFTs, meme coins, not securities. Stablecoins is relevant for the Genius Act. If they're Genius Act compliant, they're not securities. If they're not Genius Act compliant, so for example, an algorithmic stablecoin, that may be a security. And then perhaps the most important classification there is what's called a digital commodity. So those are things that we think about, like Bitcoin, Ether, XRP. There was like 15 or 17 tokens that were explicitly listed as non-securities, but effectively digital commodities are not securities if they are a token that derives intrinsic value from the operations of a network. There's no financial component to that. It's just you're getting value from the network. It's not derived from the efforts of others. So that was very meaningful. And then I know we don't have much time, so I'll just say there were other important facets of the release. They touched on activities like staking and airdropping, and specified that if you follow certain procedures with those acts, they wouldn't be securities transactions. So very helpful guidance from the SEC and the CFTC.
So it provided quite a bit of clarity, it sounds like. Yeah, so Daley, as tokenization of real-world assets moves from pilot projects to real products, what kinds of litigation do you see arising?
So one of the things that I think is important to think about when you're structuring your products is if something's being tokenized, where I see the litigation risk coming up most is the gap between the on-chain record and the off-chain ownership rights. So you have a record of something on-chain, but that doesn't eliminate the underlying frameworks of other types of laws that still apply to it. Are there contract rights involved? Are there securities rights involved? Just because you've tokenized an asset doesn't mean the securities rights disappear. So I think from a commercial perspective, I don't have to tell anyone in this room that tokenization is incredibly powerful and it has so much importance and so much can be done with it. But recognizing that what you're telling customers and what you're telling those who will own these tokenized assets, making sure that matches up, whether it's in your marketing disclosures or your contracts, having all of this button up will help avoid litigation risk, because it's when you have that gap between the on-chain record and the off-chain rights, that's where you're going to find lawsuits coming down the pipeline.
Okay, and are there any particular litigations you wish to highlight, or we're good?
Less so in that space in particular, but I think it will be interesting to see how this evolves. I think a lot of my practice right now is private practice litigation defense for crypto companies. And so I think a lot of what I do, in addition to litigating their matters, is helping them draft these, both structure the products and also draft the contracts so they're buttoned up and you don't have these lawsuits. My favorite time to be called is before anything's gone wrong, because
Which rarely happens, by the way.
But I think that's what's important. I think the goal is to avoid the lawsuits, obviously. So making sure what you're representing to the consumers is actually what you're offering and actually what they have rights to do. That's the important thing.
Right. Great. Perfect. Lewis, and I'm going to take another 5 minutes, by the way, because we were cut short. We should have had 44 minutes. So don't worry about how we go. We're going to go 5 minutes past.
You don't have 58 seconds left?
Yeah. What are the legal and operational roles programmed into various digital assets, and your thoughts about that?
Yeah, so the question was a bit more focused on, asset programmability, right? When we bring assets on chain, you have them in the standardized format, they're machine readable, then you can do more stuff with them, right? And that obviously has an enormous amount of upside, right? I was at another conference recently and was talking to a transfer agent, and he was telling me that they still do stock splits manually, right? Someone prints out a spreadsheet, puts their fingers on it, right, and adds it up. I think everyone in the audience knows that better than me, the efficiencies and higher accuracy that blockchain can provide in the equities markets and in private alternative asset classes. I have a client tokenizing private credit, and there's fascinating things you can do when you put a loan obligation on chain in terms of the maturity, in terms of ties to collateral and liquidation. I'd also highlight, with great power comes great responsibility, the risks that come with sort of, retained powers in a programmed asset. So a lot of issuers retain powers to burn a token, to force transfer a token, conditional what-if statements into a token, and you can get yourself into some funny situations. So people can brag about, not brag about, but market how their token is, compliant in some ways and can be burnt. And if it's stolen, it can be magically disappeared. That's great, and I applaud that. I think it can also be challenging, and we encourage our clients to think this through, that if you get a call saying, hey, this token was stolen, what are you going to do, right? That's a tough spot to be in. People in the industry have been in that spot in the last, 2 to 4 months, and we would emphasize, thinking through kind of what you would do in those scenarios and what you do with the powers that you retain over the asset that you just sold to someone else.
Thank you for that. Brian, tokenized securities need to have a transfer agent, just like traditional securities do. How is the role evolving for that agent with respect to digital assets? And what were some of the issues and pain points that you saw when you were general counsel or in-house counsel at Securitize in having to become the first blockchain-based transfer agent?
Yeah, so I mean, the transfer agent rules were written in the 70s, so they really are totally inapplicable to everything that you're doing with
Well, that's not true. That wasn't according to Gary Gensler. Gary Gensler thought they were fine.
Yeah. Well, we won't talk about Gary Gensler on this panel. So the rules were written decades ago, so when Securitize and others were going in and trying to become registered transfer agents, there was a lot of dialogue at that time with the SEC staff where effectively they were asking questions of us about how this would work. How do you see this working? And there was a lot of teaching going on, but to their credit, they were really, really active participants and they were putting things through. I think things have evolved since then, where the SEC has put out a statement earlier this year or late last year where they said that the blockchain can be the official record for transfer agents, which I think is a great step forward. There is some subtlety there in the sense that the SEC still expects transfer agents to have off-chain records that tell you who actually owns the security on chain. So that, we're not yet at sort of blockchain nirvana where things can really just move wherever they want and everybody is doing what they want in the DeFi world, but we may get there at some point. But certainly there's been a ton of advancement in the last few years.
Well, that's great. I have one other final question really for the full panel. But before I get there, I do want to open it up to the audience. Does anyone in the audience have any questions for anyone or on this panel before I do that? Yes, sir. Stand, please, if you don't mind. Speak up. Yep. We can.
So, you guys are talking a lot around
I can take this one.
Sure.
So coming at it from a litigation perspective, but also just a risk management perspective, the thing about agents, they have incredible promise. And also, at the end of the day, someone is still authorizing them, and they're not entirely autonomous. So when you go into a court and you have a judge trying to figure out who's responsible, there's a party or a person at the end of the day that's held accountable for that. So this is where the contracts and the drafting and the decision making, there's lots of steps along the way where you can kind of mitigate the risk. But at the end of the day, someone is accountable, and knowing who that is, you can't just blame your agent for it. So I think that's the most important thing to think about.
Accountability is the number one thing, for sure. Somebody put that agent into the world that's going to do something, and if that agent is a bad actor or does something that they shouldn't have, that whoever that entity or person is going to end up being the person that gets sued and has to pay for it.
I would view this less under genius and agree with all the comments. I worked at a quant fund for 8 years. No one would ever say that the models, right, were the ones doing it. I think you're going to run into more what is the behavior that it's doing and what is the real world analog. Is it an RIA? Is it a commodity trading advisor, right? So I think that's where I would focus, a little less on genius and more on just those other sort of regulatory regimes.
And I guess by analogy, you could think of the tornado cash case, right? Because that's involved in software, right? And our foreign governments, as well as our government, criminally prosecuted the developers of that software for Tornado Cash, right? Which is a mixer, right? Anyway, thank you. Any other quick questions before I do my last question here? Thank you for that. So for the panel, how do you see I worry about continued U.S. dominance in the world as an American citizen, hitting on its 250th year of our fine country, as well as the U.S. dollar dominance as a world reserve currency, right? How do you see the Genius Act playing a role in the continued U.S. dollar dominance as a global reserve currency? And I'll take you each down the line, please.
I think it enhances it. It definitely gets the U.S. in the game, and it increases the breadth of the availability for treasuries and the market for it, but beyond just the governments buying it. So I think it actually is a boon towards it.
Even with that central bank digital currencies.
I think so.
Right.
Yeah, I couldn't agree. I couldn't agree more. I think that legitimacy is what Genius has given payment stablecoins, and it's an overwhelmingly positive thing.
Louis?
I have no major comments here. I think I think that was the big impetus to get it passed, was national security, promotion of the American dollar, a bit on Treasury. So I think I'm very bullish on it and happy it's law.
Yeah, agreed. And I think stablecoin issuers will become the largest buyers of U.S. Treasuries, and that will have interesting effects on our national debt as well. So there's a lot to look at as this continues to roll out.
Right. I thought that was really interesting because at first I thought that we needed to play a bigger role a few years back for our own central bank digital currency because China was way ahead of us. They had in over 50 cities they had issued digital assets, of digital yuan, right? And I was worried about that as a play by China to make its currency the global reserve, right? But in one sense, the Genius Act was genius in the sense that it requires US dollars to back it up. So it eliminated the worry about the central bank digital currency, the privacy concerns, and the banks being concerned that, well, wait a second, that's going to take away our deposits. And so that kind of fell, but the Genius Act solved that problem to some degree. So I think that was really interesting. I want to thank this amazing panel, please, for their participation and thoughts today.
Thanks, guys.